So yesterday we finished the powers. We also finished vetoes and ordinances. We did some previous year questions. We covered the judicial powers comparatively between the president and the governor. Now, one small segment is left for layer two of this topic, which is your analysis of the office of the governor, for which you will find notes directly on your drive, and this is only and only important for the mains. So all you have to do is go to the mains notes, go to updated notes, and go to theme 6, because this is the sixth point under your mains syllabus. That's how we've organized it. All right. The appointment to the governor. All of you can open the corresponding slide from the drive. So the agenda, or what we should be discussing in this topic, is figuring out how we can make the governor's office more substantial and what kind of reforms can we make to the governor's office. And given the fact that the governor is appointed by the center and removed by the center, is the governor really an agent of the center, right? We should be answering these questions in a substantive amount of detail. This is, again, I'm reiterating, primarily important for the mains. I'm going to give you a few reference Supreme Court judgments, and then of course we will look at the technical details in and around it. Okay, so let's begin. Appointment of the governor. Let's get some basics right that we had discussed before also. Article 153 states that every state shall have a governor. It does not mean that there will be a separate governor for each state. You can have a joint governor of more than one state, of a state and a union territory, of two union territories, of a single union territory. In that case, it becomes the lieutenant governor. So, of course, those are things that are perfectly permissible. Article 154 states that the executive power of the state shall be vested in the governor. This is a corresponding article to the one for the president, where it says that the executive power of the union will be vested in the president. Now, under Article 55, it is said that the President of India who appoints the governor. However, the President exercises this power on the aid and advice of the Council of Ministers. Now, this is constitutionally mentioned. We've discussed this before also. However, to make sure that there is some confidence building measure and to make sure that the states are involved in this process as a matter of convention and not provision, it has been sort of devised as a convention over the years that the chief minister of the state is consulted before the appointment of the governor, right? Now, therefore, what do we understand? That the office of the governor is technically a nominated one or an appointed one, but certainly not an elected one. And if you get this question and you have to justify why the governor is an appointed or a nominated a post, not an elected one, there are essentially four reasons behind this. Reason number one: an appointed governor by the center means that the governor is not going to be biased towards the interest of the states, as the governor will not be dependent on the choice of the states. And as a result, it is expected that the governor will promote all India unity and not a separatist provincial tendency. And all India unity and not a separatist provincial tendency. Now, the governor is an because the governor is a nominal head, there is absolutely no need for spending so much money on the election of the governor, so many resources on the election of the governor. One could argue the same for the president as well. But the president is not just the president, you're the head of the state, and therefore there has to be a substantial spend of resources for you to become the president. And the president does exercise certain extraordinary legislative powers, consolidation powers, such as an emergency, such as assenting a few state bills, and so on and so forth. So if you are a nominated person, if you are an appointed office, why spend so much time? Why spend so much time, on the appointment, on the election of the office, right? Third, an elected governor will always belong to a party, whether you like it or not. You can make it by law that they are supposed to be impartial like the president, and you should try and make it by law. But just because the law says you're apolitical does not necessarily mean that you're apolitical. I mean, we all have understood, given the substantial role of the Lok Sabha in the presidential election, the president will always be a candidate which is endorsed by the majority party at the center. And if such is the case, while the president is officially not a part of any political party, that does not mean that the president is going to be a part of is not going to have some camaraderie with the government in power at the center, right? And at the end of the day, there will always be conflicts between the chief minister and the governor if both of them have been elected by the people, as there will be a duality of leadership at the states, and the residents of the states, the people in the state, will therefore have a divisive way to look at it. And if you think about it, this would create a juxtaposition of sorts of a parliamentary and a presidential form. If the head of the state in a state and the legislatures of the state both are directly elected by the people. So keeping these four reasons in mind, it was devised by the makers of the constitution that the office of the governor is going to be a nominated one, a chosen one, an appointed one, but certainly not an elected one. So when we understand this, we move further on to understanding certain technical details. Now, when we look at the removal, we've discussed the broad areas. Now let's get into a little bit of analysis. Though ever since the paper has changed from 2013 onwards, I haven't seen a specific question on governor. That's also largely to do with the fact that the term governor per se is not mentioned in the syllabus. So governor in the context of federalism can be asked, but independently an analysis of the governor's office seems slightly far-fetched, but because it is such an important constitutional position, to just be safe, we are covering it to make sure that our grounds are comprehensive. Now, uh, I hope all of you will appreciate the small little images that are a part of these slides. They have a political context. They have a political satire with each of the images that you would find on the slides. Anyways, so Article 156, Clause 1 clearly states that the governor holds office during the pleasure of the president. During the pleasure of the president. That means as long as the central executive wants the governor to be in office. Now, this also converts into a constitutional doctrine called the doctrine of the pleasure of the president. Okay? Doctrine of the pleasure of the president. Now, doctrine of the pleasure of the president. This means that you're appointed and removed entirely at the will of the president. Now, this means that the Council of Ministers can advise for your appointment and can advise for your removal, and you would be removed effectively. Effectively. Like, for example, in your case as civil servants, though your appointment is made in the name of the president, you don't hold office per se during the pleasure of the president, because there is a constitutional process. You all have been granted constitutional immunities, and as a result of which, it is not that easy to remove you from the services. Now, which also means that the center can recommend the president to remove you on any ground, and there is no law, there is no constitutional provision recommending the center to disclose the reasons as to why you are not kept in office. Of course, there has been the SR Bommai judgment, which very clearly the Supreme Court has endorsed, that the reasons should not be political, should not be abstract, should not be things like the governor does not hold the ideological congruence with the center, or the governor is inefficient as such. The governor is a very sanctimonious office, and the reasons for removing the governor must indeed be very, very grave. Unfortunately, we are still not implementing that judgment in its true letter and spirit. Now, like the president, the governor also holds a term for 5 years and can resign in writing by resigning to the president. Now, unlike the president who is impeached, the governor is not impeached because you hold the office during the pleasure of the president. And because you are, well, technically a majority appointment or a political appointment which is made on political conditions, very often it happens that if you are appointed on political considerations, you will often be removed on political considerations. So if you think about it, a lot of times senior veteran members of a political party, or several civil servants who've retired, but their work has been appreciated beyond a point by the central government, they are often offered the posts of the governor of a state, as a glorious way to end the career in public life. So if your appointment can be made on political considerations, then your removal can also be made on political considerations. Now, what has happened over time is that the governor's tenure, for as long as how much time a person can continue to be a governor, has become in fact a very hotly debated federalism issue, and it has become a very hotly debated federalism issue because it is often argued that the central government uses the uncertainty of tenure. That, imagine getting into the civil services and every day worrying whether you're going to have your job by the end of the day because of the decisions that you make. Sometimes you may want to genuinely represent the interest of the states at the center. And there have been historical cases where a few governors from the state of Kerala have really fought for more funds for Kerala's development for a couple of other states. But the idea is that because you have a lot of uncertainty with your own job, it is often considered as an important factor to influence your decision. This is also true with civil servants. While you cannot be while you cannot be removed from service as such, but the fact that you could be transferred literally at the drop of a hat, the fact that you could be asked to shift your base of operations at the drop of a hat, that is indication enough, that is reason enough for you to perhaps want to make a certain kind of decisions. That's why people in the civil services also end up choosing their sides of political loyalty sooner or later, and only a few truly remain independent civil servants, which is also true here in the office of the governor, because then when your very existence is dependent on somebody's discretion, and please understand the words that I'm using, when your existence is dependent on somebody else's discretion, it is very difficult for you to exist impartially. It's very, very difficult for you to exist impartially. And that is something we must always understand. Now, what if the governor has, done something and has to be removed? And if the removal is questionable, it's flawed, then in 2010 we've had the BP Singhal judgment. The facts of the case are not really that important, and that's I don't want to confuse you with so many facts or so many cases. All that I want to tell you are some Supreme Court guidelines on the review of governor's removal. In this, the Supreme Court has categorically said that governors can't be dismissed arbitrarily on the ground that the precedent, that the center has lost confidence and does not agree with center's ideologies and politics. That's a very, very broad ground. That's very, very open-ended to begin with. And similarly, just because you hold office during the pleasure of the president does not make you an employee or a servant of the union government. You still hold a constitutional post. You are a constitutional authority, and that comes with a certain amount of dignity. And the Supreme Court very keenly and rightly observed that the constant threat of the removal of the governor's office will automatically make you biased and partial to serve the interest of the central government at the respective states. And therefore, there must be some inbuilt safeguards, some ways in which Article 156 could be utilized in the form that it was intended to. The whole point of the system that we had set up was not to give the center exceeding powers over the states. That's not the point of this. The point was that we needed to create a uniformity of communication and a uniformity of policy making from the center and the states. And the governor was supposed to be an instrument of federal communication. Today, it has now become very oftenly a trumpet of central subservience over the states. So therefore the court very rightly again held that if the affected person, if the governor who was removed can prove that the removal was arbitrary, which means without just cause, or for the wrong intentions, that just for political reasons, or let us say was questionable, or was just very, very, without any reasonable reason behind it, then you can ask the central government to disclose in the court the reasons why the central government decided to remove the governor, right? And therefore, even if the removal is not to be assigned, in the sense that even if the courts can't overturn the removal per se that easily, the courts can definitely look into the reasons given by the center to remove the governor. Now, interestingly, you will very rarely see governors taking this up to the courts, because at the end of the day, the people that the central government will appoint will often be people close to the central government, right? And therefore, the concluding statement would be the doctrine of presidential pleasure without limitation cannot be applied in India where the rule of law prevails, because this is nothing but the arbitrary action, and we all know that any arbitrary action is the very opposite of what is called rule of law. Any arbitrary action is the very opposite of rule of law. Now, let's come to the position of the governor in the state. Now, when we look at the position of the governor in the state, what do we understand? We understand that unlike the president, who's largely playing a national figurehead kind of a role, the governor is playing a dual role. Now, this means the governor is the head of the state as well as a representative of the center in the state. So there are two things that you have to do. First, you have some responsibilities at the head of the state. So the governor is the head of the state right? So you have certain responsibilities, certain manifestations of that responsibility. And second, of course, you are at the end of the day sent by the center. Now, as a representative head of the center, what is it that you're supposed to do? As I was telling you, you're supposed to have you're a very important link of communication, of the transmission of ideas and aspirations that the center has for the states and the states have for the center. And therefore, it is the duty of the governor to keep the center informed about the affairs of the state. And an aggressive application of this is that the governor can recommend to the center that the law and order machinery has broken down in the state, and therefore a presidential rule may be necessitated at the same time. It is also very interesting to notice that the center doesn't have to necessarily wait for a governor's report on the same, but the governor, if the governor wants, can certainly recommend this to the center. And this therefore helps the center discharge its constitutional responsibilities towards the state and acts as an agent of the center when the proclamation is made under 356, which is presidential rule. Now, as the constitutional head of the state, the governor performs very similar functions as to those which are enjoyed and performed by the president, such as the appointment of the ministers with respect to certain parliamentary legislative functions, such as dissolution of a house, prorogation of the house, and so on and so forth, introduction of certain bills in the house, assenting certain bills in the house. And therefore, while the ministers are dependent on the political majority in the assembly, the governor is there for 5 years and therefore assures a sense of continuity in the state. See, very interestingly, most states don't have legislative councils, which means most states don't have a permanent legislative chamber. We will discuss this in the parliament as to how the Rajya Sabha is a permanent house, which means all the members of the Rajya Sabha don't change at once. That's why it's called a permanent house. In most states, that's not the case, because most states have legislative assemblies, and every 5 years the entire assembly panel changes, and ministers can also keep come and going in case there are fluctuations in the politics at the regional level. So in one sense, the governor also provides as a system of continuity, as a system of balance and sort of consistency at the state, and therefore becomes a key functionary in the system envisaged by the Constitution of India. Now, let's understand what is the relationship that the governor has with the Council of Ministers. Firstly, it is important for you to know that the relationship that the governor has with the Council of Ministers is very, very similar to that of the president, right? And how the president works with the Council of Ministers at the center, which means that in most circumstances, the governor has to act on the aid and advice of the Council of Ministers, except in the cases where the Constitution has authorized the governor to exercise powers in their discretion. And I've told you discretion, such as deciding which bill could be reserved for the office of the president, or, for example, recommending to the president whether there should be presidential rule at the states. Now, obviously, you can't ask the Council of Ministers on whether we should put presidential rule in the state, because the Council of Ministers would obviously say no. So that is why it was only logical for these to be discretionary powers given to the office of the governor. Now, Article 163(1) says there will be a Council of Ministers to aid and advise. We've covered this. Now, if there is a question whether something is discretionary as for the governor or not, then Article 163 Clause 2 applies, which says that if there are any questions whether a matter comes under governor's discretionary power or not, if you are not sure whether this is a discretion of the governor or not, then the decision of the governor with respect to whether this is discretionary or not will be final and not called into question or not reviewed under circumstances. Right? Now, this is also true for Article 163 Clause 3, which says that the advice which is being given by the Council of Ministers to the President, the same way the advice which is given by the Council of Ministers to the President, right? That cannot be, inquired into. The material that they have relied on to give that advice, that can be inquired into. We applied this provision for ordinances, right? You cannot question the advice, you can't get into the intention, but you can get into the resources that you have relied on before, giving advice by the Council of Ministers to the governor. And therefore, we understand that the makers of the Constitution gave very explicit and extremely wide discretionary powers, right, on the governor, because as the representative of the center, the governor has to serve as the eye and the ears of the center, and so needs independence and discretion in certain matters, and therefore you're also an important link between the center and the state to maintain what is called the unity and the integrity of the country. Okay, good. Now, how is the governor very particularly different constitutionally from that of the president? First, the constitution explicitly provides for the governor to act in their discretion, but it has no such thing has been mentioned in the president, and we've discussed this. The president has zero dedicated constitutional discretion. Now, this is also an appropriate time for me to explain this to you. So, when we talk about discretion, there are basically two kinds of discretions. One is a constitutional discretion, and the second is what is called a situational discretion. One is called a constitutional discretion, and the second is called a situational discretion. Now, what is the difference? And let's understand this. A constitutional discretion is explicitly mentioned in the constitution, that by XYZ provision of the constitution, you are allowed to act in your own capacity. You don't have to consult, your respective set of ministers. Whereas situational discretion means that the circumstances are such that you do not have the council of ministers to really advise you, and therefore any decision that you have to take will automatically be a decision on your own and therefore be discretionary. So as far as situational discretions are concerned, both the president and the governor enjoy equal discretionary powers, because these are not explicitly mentioned in the constitution. These are derived, these are implied. But when it comes to dedicated discretionary powers, it is only the governor that gets these powers and not the president. And the governor gets these powers primarily in two forms. One, for reserving the kind of bill that they want to for presidential assent, and second is recommending for a presidential rule under Article 368. 356. Okay, this is basically presidential proclamation. Now, this also is an amazing application of rule number 2, because if you understand this carefully, the governor has been given more discretionary powers than the president. Technically, is a candy that we've given to the governor, thereby satisfying the concerns of the states. But the reality is, the governor is appointed by the center and will never use these powers against the center. If the center wants the governor to make a report on the breakdown of machinery, which can be grounds enough for presidential rule, in all likelihood, the governor is going to make such a report, is going to recommend something like this to the center. So therefore, it is certainly a matter of understanding. Now, let's get into the other technical details, right? So that's the explicit point. Now, secondly, the Council of Ministers can be asked by the President to reconsider their advice, to come back with an alternate proposal, but no specific constitutional provision exists like this as far as the governor is concerned. And thirdly, The Emergency Constitutional Amendment of 1946 very clearly said that the ministerial advice, the advice given by the Council of Ministers to the President is binding, but there is technically no specific provision with respect to this for the governor, because it really makes no difference, because they are usually bound, and in case they don't follow, then these could be violations of the constitution, right? Now, through various articles of the constitution, you're able to understand that there is an express discretion of the governor which is required, but in most cases, right, in a lot of other matters, except where you don't require discretion, the governor has to act in harmony on advice with the Council of Ministers. And this was devised in the case of Shamsher Singh versus State of Punjab, because the constitution does not want to provide for a parallel administration within the state by the governor going against the CM. So you can't have the governor acting in consonance with the president, which is basically the center, and a parallel powers game in the state headed by the CM. It is only going to lead to the collapse of the entire machinery and the systemic ecosystem at the level of the states. Now, when we look at the discretionary power of the governor, when we look at the discretionary power of the governor, what is it that we understand? Where is the discretion lying? I'll give you a few examples that you can quote. So, as I said, as per the constitution, by or under the governor's discretion, you could always, make certain decisions. These decisions may sometimes be express, sometimes these powers may be explicit, sometimes they may be implicit. Now, it is in the following cases, the ones that I have mentioned here, that the governor has a constitutional discretion. That means the constitution mentions that the governor to exercise these functions in their opinion, discretion, independently of the Council of Ministers. For example, under Article 200, reserving a bill for the president. Under Article 356, recommending a presidential rule in the states. Under Article 239, Clause 2, when you're working as a joint administrator of an adjoining union territory. And this is also logical because the union territory is a centrally administered region to begin with, and very specifically some special powers given in the context of Assam, where the governor gets to decide how much money should the state government of Assam be paying to the autonomous district councils of Assam as a royalty which they are entitled to if there are any mines and mineral exploration exercises that happen in the region, right? Of course, apart from this, the governor also has certain special powers under Article 371, wherein, and we'll do the special states under 371 later, but there are some special powers given to the governor under 371, wherein through with your discretion, and in case of a special responsibility, you may consult the COM, but the final decision would be with the governor's choice. These are basically to set up special development boards in Gujarat, in Maharashtra, administration of tribal areas in Assam, hilly areas in Manipur, law and order in Arunachal Pradesh, Nagaland, etc. It's the final call of the governor which comes into question. So these are some of the discretionary powers that I've taken from the entire constitution and put in one place so that you can write this as it is in your mains answers. Okay, now when we talk about the situational discretion, Now there are some very specific examples that I have given, but don't worry about it too much. Let's talk about the situational discussion. So what is the situational discussion? Suppose there is no clear majority, then the governor can use their own wisdom and decide which party do they want to form government, and then inform the party that sooner or later there could be a floor test, which means the party may have to prove its majority on the floor of the house for you to continue as the majority party. Cases with Rajasthan, Madhya Pradesh, Karnataka, they've been very recent ones. So I'll give you a few examples. Under Article 164, Clause 1, when no party has achieved a clear-cut majority, or when the chief minister suddenly dies and there is no obvious successor, in these cases, the governor can call any person to form government who the governor thinks can command majority, right? Now, for example, in the Pratap Singh Rajirao versus Governor of Goa, the governor held the court held, sorry, that the purpose of this, for the purpose of appointing the chief minister, the government is acting in the sole discretion, and while taking this decision, this sole discretion, you enjoy immunity under Article 361 of the Constitution. So you cannot be charged with fraud, you cannot be charged with conspiracy, no such actions can be taken, because when you don't have a minister to advise you, then you're obviously using your own wisdom and your own mind at that particular time. Similarly, there was a case of appointment of a non-legislator as a chief minister, that the very chief minister was not an MLA at the time of becoming a chief minister. These cases will not be asked. This is just to give you an example. In B.R. Kapoor versus the state of Tamil Nadu, the court said that no problem. A person who's not an MLA or an MLC can become a CM, and that's absolutely not an issue, even in a situational discussion, as long as you are eligible to become an MLA under 173 of the Constitution, and you're not disqualified, and you cannot be disqualified under ordinary reasons to become one. Right? This is true for general setup also, that you can be a minister if you're not an MP, but you've got to become an MP within 6 months or an MLA within 6 months. Even in the cases of a hung parliament or a hung legislature with no clear majority, you can still continue to do this. And finally, in Anil Kumar Jha, the governor appointed the leader of a party which was not having the right kind of numbers, but the court said cannot, and the court said that there has to be some reasonable exercise of that power. So I understand that suppose one party has 100 seats, the other has 90 seats. You choose either of the two and say, even if the 90-seat party is able to, command majority and get the right numbers on their side over a period of time, that is still fine. But if somebody is 100 seats and somebody is 30 seats, there is no way the 30-seat party is going to get the kind of majority that the 100-seat party is going to get. So play your cards right. Just because you have a discretion doesn't mean that you use your discretion blindly. That's actually what happened with Kerala also. Anyways, the Congress had more number of seats, but the governor at that time invited the BJP to form government and all of those things. Now, when the government loses a no confidence motion or loses a floor test, and therefore you do not have a majority, if you don't have a majority, then you can't continue to be a minister. So under Article 164 Clause 2, it is very clear that the ministers are collectively responsible to the state legislative assembly. Hence, if a ministry has lost confidence of the House and refuses to resign, then the governor can dissolve the ministry, even if it is the chief minister. Now, there are 2-3 judgments, very technical. Just to explain to you, You can write a very smaller form of this in the exam. In Mahabir Sharma versus Praful Chandra Ghosh, the Calcutta High Court had ruled that if the Council of Ministers are refusing, कि हम नहीं जाएंगे, we refuse to vacate the office of the ministers, even after you have, lost the motion of the confidence, lost the motion of confidence in the House, then the governor can withdraw the pleasure. This can also lead to the imposition of presidential rule as well. And the governor, the court very clearly held that the governor's right to withdraw the pleasure is entirely absolute. It is unrestricted and it is a discretionary power of the governor. In Jagdambika versus State of UP, the Supreme Court directed that convene a special session and have a proper floor test, a composite floor test between contending parties, whether it's Shri Jagdambika Pal or Kalyan Singh. बुलाओ हाउस में और चेक करो कि किसके पास majority है ही नहीं. That means that it shows that the governor's discretion to dismiss a ministry or a government should only be exercised when the chief minister has actually failed to prove the majority on the floor of the house by all means possible. You can't assume this. Unless there is an absolute failure of this, you can't get into further problems here. Now, in Jogendra Nath versus State of Assam, commenting about the discretionary power of the governor or in appointing or dismissing the chief minister, the Guwahati High Court very clearly said that the repository of the power to appoint chief ministers to withdraw the pleasure contemplated under 164 or dismissal of minister exclusively, pleasure come direction of the governor, is the sole authority to appoint the chief minister, which basically meant that the governor used their discretion saying you don't have the majority, you can't become a chief minister, to which the court said fair enough, it is your discretion as long as you're using it for the right reasons. We have absolutely no problems whatsoever. In the mains, even if you just write 1 and 2 and not write the Assam judgment, that's also fair, you don't need to do anything else, right? Because you will get a collective question, you will not get a detailed question. Now, third, when the governor has to dissolve the state legislative assembly. Now, what has happened is different governors across different states have used, different kind of approaches. Now, what happens here is the advice of the chief minister enjoying majority support is usually binding on the governor. Like, for example, let us say 5 years have ended. The chief minister will recommend. Now, when the chief minister has already lost such support, such kind of majority, right? And the governors have sometimes refused to dissolve on the advice, and in some cases, some have taken the advice also. कई बार क्या होता है कि no confidence fail होने वाला है. So the ministers tell the governor, बाहर बेइज्जती हो, आप house से dissolve कर दो, right? In some cases, the governor say, okay. In some cases, the governor says, no, take your time. Get a few MPs, MLAs from here or there, and we'll see what can and cannot be done. Okay? Anyways, so situational discretion is situational discretion. Now, then comes the question that every UPSC aspirant often manifests itself with. Is the governor an agent of the center or not? Now you see, the governor is an appointee of the president and therefore holds office during the pleasure of the governance of the president, right? Now this is also true for the president. Now you must understand that the president is bound to act on the aid and advice of the Council of Ministers as per Article 74, and therefore it is the central government that appoints and removes the governor. We've discussed this. So if you think about it, the pleasure of the president actually means the will and the wishes of the central government. The president is merely the face of that decision, the medium, and just a messenger. And one must not shoot the messenger, but of course the person who sends the message to begin with, right? Now, the constitution is strictly against compromising the autonomy of the states. So if you're appointing governors for political ideologies or rewarding people with some past actions, that is something that we should not do. Because what happens is it leads to over centralization, and then you come up with terms like, is the governor a center of the agent of the center, or a spy of the center, or just a rubber stamp, and so on and so forth, right? Now, but keeping this in mind, we then must understand, is that the case? If you see, there are several recent instances where BJP is in power. So what will happen is, remember, if the BJP is in power, they will always send, say for example, in Congress governed Rajasthan, Kalraj Mishra, right, who's a politician, a former cabinet minister in the BJP, was appointed as a governor in 2019. Bandaru Dattaraya, BJP Lok Sabha MP, was appointed as governor in of Himachal Pradesh. Tamilsai Soundarajan, appointed as governor of Telangana, former state head of BJP in Tamil Nadu. C. Vidyasagar, BJP member, was replaced by another BJP leader, Bhagat Koshyari, in Maharashtra. Arif Khan has been appointed as the governor of Kerala. He had earlier quit the Rajiv Gandhi government over the Shah Bhanu case, and has been, referred to many times by the BJP. So the question here is, unless the party ruling is a non-state BJP party, there is no check over the appointment of the governor. Now, very interestingly, though the constitution does separate, the center and the states, and grants the latter some form of autonomy, due to these biased nominated appointments, and you have to call a spade a spade. This is true during the Congress regime also. So you will always have people that you are more comfortable with, and therefore as governors, and that is sort of shrunk and has reduced the magnanimity of what the governor's office could have been, and we're moving closer to the question of agent of the center. Now, you must understand that it never was supposed to be like this. It was never supposed to be the governor working, in the larger interest of the states. But today, there is a problem, and which is why there's an urgent necessity to depoliticize the post of the governor. Okay? Depoliticize the post of the governor. Now, what are the broad reforms? Now, what I've done is I've given you some points, and I've also given you a full table for governor reforms. Okay? You don't need anything else. So there's the Sarkaria Commission. Remember, I was talking to you about yesterday. There was a prelims question also on Sarkaria Commission. So 1983, submitted report in 1988, recommended changes to center, state, legislative matters, role of governors, and use of 356. Now, direct question verbatim from here in the pre. Eminent in some walk of life outside the state, should be a detached figure, not be a member of the ruling party, appointed after consultation with the chief minister, the vice president, and the speaker of the Lok Sabha, should only be removed on grounds mentioned in the constitution, or as if you should add constitutional grounds firstly, or if it's a morality, dignity, or a constitutional issue. Then ARC says that governors should be non-partisan people, should have a long experience in public life and administration. And most recently in 2007, the Punchi Commission said that should have stayed away from active politics from in any form for at least 2 years. There should be a committee set up comprising of the PM, the Home Minister, Speaker of the Lok Sabha, concerned Chief Minister, Vice President, and only a resolution which should be passed by the states should be the reason why the governor should be removed, so that there is a procedure of impeachment of the governor by the legislature, how there is an impeachment of the governor by the president. And this entire drama of doctrine of pleasure should be deleted by the governor. Okay, of course, none of this has been implemented except for consulting the chief minister, which is also a convention and nothing else. Do we understand this? Is this clear? Is this fine? Okay. You can take a 5-minute break, and this is how your president and your governor is complete as far as the theme is concerned. Yes, you can keep adding contemporary developments from the newspapers here. You don't have an option for return then, Vaibhav. Under presidential rule, if the Council of Ministers don't exist, then the position of the governor is that you work on the aid and advice of the president. तो सारे निकाल के रख लो भाई. All right. Now we are left with a very small topic. Now let's understand Council of Ministers. Now, let's start the Council of Ministers. Let's first figure out the layout of the Council of Ministers and figure out exactly what it is that we're going to be doing as far as the Council of Ministers is concerned. Now, you would remember that when we were discussing the broad layout of the center and the state and everything else together, we had largely understood how the Council of Ministers work, and we had understood exactly how the Council of Ministers and the types of Council of Ministers and so on and so forth. So we're going to study all of that in the right amount of detail at the moment. Okay. Now, the outline. Layer 1, which is conceptual and factual and therefore important for the prelims, and layer 2, which is analytical in nature and therefore important for the mains. And we're going to discuss Council of Ministers respectively for the center and the states. First, you must understand the appointment, the removal, and the oath. Second, you must understand a word called collective responsibility. A word called collective responsibility. Third, we should understand the strength. That's it. If in the prelims there is going to be a question, the question is going to be from here. Okay? No, Prakhar, I will discuss this in center states as a separate topic, not at the moment. Now, in the mains, there are two kinds of questions that can come. One, on the cabinet form of government. One, on the cabinet form of government. And two, what is the right strength, an application here, and what is the right strength, the appropriate strength of the number of ministers. Okay, the appropriate strength of the number of ministers. चलिए, first let's understand some terms and then we will continue to discuss everything else. Now, here these are called Central Council of Ministers. Here these are called State Council of Ministers. Now, this is the collective term. This basically means the total number of ministers of any kind in any capacity. Alright? Now, what are the different kinds? Of course, headed by the PM. Then you have something called a minister who is the in charge of a large or a big ministry. Education, health, finance, home, foreign affairs, etc. Then you have a minister of state who is assisting or an additional minister to a minister of a big ministry. So you will have MOS Finance, MOS External Affairs, MOS Education, MOS Health, stuff like that. Then you have MOS IC, the Minister of State Independent Charge. This means you are an in charge of a relatively small ministry. Okay? You are in charge of a relatively small ministry. This is exactly the same here, where instead of the PM, it becomes the CM. Small ministry here would be, say, tribal affairs or civil aviation or Panchayati Raj and so on and so forth. Okay? Now, the total number of the ministers at the center cannot be more than 15% of the strength of the Lok Sabha, and this is by the 91st Constitutional Amendment 2003. Similarly, the number of ministers at the state should not be more than 15% of the strength of the state legislative assembly, but you will have a minimum of 12 ministers, and this is again by the 91st Amendment 2003. Now, very interestingly, the purpose of inserting something like this was to essentially prevent the misuse of political opportunism, the misuse of political defections. So a lot of times what was happening was members were moving from one party to another as the majority party was luring the MPs or the MLAs by giving them the positions of a ministry or a ministerial berth, which is why the 91st Constitutional Amendment is more popular and is more well known for the changes it introduced in the 10th schedule with respect to anti-defection law, right? So the origin of restricting the number of ministers is not to stop the overpopulation. Of course, there are administrative reasons behind it also, that too many cooks indeed spoil the broth. But the more apparent and the more compelling reason of passing the 91st Amendment was essentially to ensure that political defections could be reduced. That if you only had X number of people that you could make a minister, then under no circumstances will you be able to induce other people from leaving their political parties and adding to you, thereby getting you the majority and being rewarded what is called a ministerial berth, right? Now, this is the general setup that happens. Comes the next question, which is extremely important. As far as the oaths are concerned, right? The oaths for the center and the states. The oaths for central ministers are given by the president. The oaths for the state ministers are given by the governor. Okay. Oaths are given by the center as far as the president is concerned, and state as far as the governor is concerned. Now, let's understand this as clearly as we can. We're now going to talk about responsibility. Now, there are two kinds of responsibility. One is a collective responsibility, and the other is an individual responsibility. Now, both of these mean very different things. So, as far as collective responsibility is concerned, the collective responsibility of the central ministers is through the Lok Sabha, and the collective responsibility of the state ministers are at the state legislative assembly, which means that a motion of no confidence can be introduced in either of the two houses to remove the entire ministry, and that happens, then the government falls and the houses are dissolved and a fresh set of elections can happen. So if the ministers have lost majority in the houses, then they don't have the reason to continue because they've lost political status in the houses. This is collectively. This is called the doctrine of collective responsibility. If in the prelims you get a question, remember, central ministers collectively responsible to the president, and state ministers collectively responsible, responsible to the Lok Sabha, and state ministers collectively responsible to the governor, right? Now, individually, which means at the end of the day, the ministers are like a team. There is a CEO, there are several vice presidents of, marketing, of product, of technology, of legal, of HR, right? So you could say that the entire company leadership can be removed by the stakeholders or the shareholders of the company. But one individual, official of the company, one individual employee of the company is a part of the CEO's team, is a part of the founder's team. So similarly, your individual responsibility is to the Prime Minister here and to the Chief Minister here, which means the PM and CM can recommend to the governor and can recommend to the president, right, respectively, to remove a specific minister and make somebody else. This is only on the advice of the PM and the CM because they are the head of government. They get to decide who gets to be a part of their team, right? So this is what is called your individual responsibility. So you're appointed by the president, you're appointed by the governor, you are given your oath by the president and given your oath by the governor, but you are removed by the president and the governor individually only on the advice of the Prime Minister and the Chief Minister, respectively. This is something you must very clearly understand. Okay? So this is how it's done. This is how people are made ministers, and this is how people are removed from being ministers. Now, if you really look at it, right, if you really look at it, let's say the number of ministers. Can anyone tell me the number of ministers in the current Lok Sabha? Yes, around 80. Very good. This cannot be more than 15% of the strength of the Lok Sabha, which is cannot be more than 15% of 543. And how much is that? Okay, good. If this is about 81.4, you could call it 81. You can't have more than 81 ministers. Now, this means a lot of decisions has to be taken by the government on a lot of issues. You can't call all 80 approximate ministers at the same time, which is why the concept of a cabinet comes into picture. The concept of a cabinet comes into picture. So cabinet is nothing but a selection or a group of important ministers. A group of important ministers. Every government decides who's going to be a cabinet minister and who's not going to be a minister, and they take decisions on behalf of the entire council of ministers. This is true for the center and this is also true for the states. I'll show you something very interesting. Wait. See, Prime Minister is the head of the ministers. Now see the kind of ministries our Prime Minister is currently holding. He is the Prime Minister of India, which means he is the head of all the ministries, and he also is in charge of 3 specific ministries or 3 specific departments. So what you must understand is, this is how it looks like. So a ministry is usually divided into departments, and then departments usually have some form of divisions or sections or something like that. So if, for example, this is the education ministry, there is the department of school education and literacy, and there is the department of higher education. So this is how ministries are usually organized. Okay. Now, see, this is how it works. This is your Prime Minister, right? Yes, 81.45. Yes. So approximately 80 odd ministers. Now see, the Prime Minister of India today holds the Ministry of Personnel and Public Grievances, Department of Atomic Energy, Department of Space. So these are the 3, one ministry and 2 departments come under the Prime Minister of India. Then you have a bunch of cabinet ministers. So who are the cabinet ministers? You've got defense, you've got transport, cooperation, corporate affairs, external affairs, agriculture, tribal. इन सबको हमने यहाँ corporate में ही डाल के रखा है, सबको. अब सबको. And then you have independent charge. So you'll see planning, statistics, Ministry of Earth Sciences, and all of those. And then you have MOS, Minister of State. So see how this Minister of State works. Corporate affairs, tourism, the second in charge, right? Jal Shakti, consumer affairs, steel, railways, power, social justice, law, finance, and so on and so forth. So these are your broad ministerial divisions. Now what happens here is that right now we look at ministers and cabinet ministers as an equivalent term, but that's actually not the case. The cabinet can be a smaller section of council of ministers as well, right? But you can call it interchangeably, that is fine, that's entirely up to the government. So this government has done is that ministers are also called cabinet ministers, but then you have a few who will then be a part of something called cabinet committees. So this gives the rise to something called cabinet committees. Okay, so then this cabinet becomes a part of something called cabinet committees. These cabinet committees take key executive decisions. Often you would read in the newspapers that the cabinet has approved this bill, the cabinet has cleared the funds for this project, the cabinet has announced for this. So the word cabinet committee comes from here. So you have several. For example, you have a cabinet committee on appointments, you have a cabinet committee on economic affairs. They are the ones that approve major infrastructural projects. A lot of your key appointments to constitutional bodies, to senior offices, they're approved by the cabinet committee of appointments. So do you know how that works? This is how it works. For example, let us say you have to choose the CAG, right? Now, the Cabinet Committee on Appointments will have a few recommendations. Will from here choose a name for the CAG. This will be on behalf of all the ministers, and this name would be recommended to the president, and the president will then appoint the CAG. So this is how your cabinet committees actually work. Okay, that's how your cabinet committees actually work. Okay, so this is the basic ecosystem. This is largely how it is done, and you don't need to really know anything else beyond this. So as far as our prelims is concerned, as long as you understand the appointment, the removal, the oath, the removal of an individual minister is nothing but individual responsibility, and collective responsibility is a motion of no confidence. You know the strength, you know the collective responsibility, and you know the appointment, removal, and oath. You don't need anything else at all under any circumstances. Now, to understand cabinet form of government, right? And this is something you must understand as clearly as possible. This will usually happen in the case of a parliamentary form of government, because you're choosing your ministers from the legislatures. So, when we discuss the parliamentary form of government in the next theme, as a subset of parliamentary form of government, we will discuss the cabinet form of government, and that is how we will be able to analyze what is the appropriate strength of ministers that India should have. So, the point I'm trying to make here is so Sandeep, there can be a difference if the government wants it to be a difference. Of course. So now let's understand this. So layer 2 of this particular topic in theme number 3 should be done with layer 2 of theme number 4, which is actually the parliament, so that you understand this. Once you understand an analysis of parliamentary versus presidential forms, then you will understand how cabinet form of government and what an appropriate strength of the ministry should be. So that is it. Sandhya, the difference between cabinet ministers and council of ministers is, if the government wants, then you can reduce the number of you can have a smaller section from the council of ministers and make them cabinet. Council of ministers is everybody, including MOS, IC, and Minister of State. Okay, ministers and cabinet ministers are often used interchangeably. Otherwise, they could more or less be looked at from the same point of view. Okay, okay. Are we clear with this? Do we understand this? Yes. आपको समझ में आ रहा है कि ये मैं क्यों कह रहा हूँ? मैं आपको बिना पार्लियामेंट्री सिस्टम पढ़ाए अगर मैंने आपको मिनिस्टर्स का ज्ञान दे दिया, तो आप उसको पार्लियामेंट्री अकाउंटेबिलिटी से रिलेट नहीं कर पाओगे, एंड दैट वुड बी अनफॉर्चुनेट एंड दैट वुड बी अनफेयर टू यू. तो जब हम पार्लियामेंट्री वर्सेस प्रेसिडेंशियल फॉर्म डिस्कस करेंगे, इनफैक्ट वी आर गोइंग टू डू दिस स्टार्टिंग इफेक्टिव इमीडिएटली फ्रॉम टुमारो इटसेल्फ, आप ये देखोगे, right? You will very clearly understand why is it that we're going to be doing something like this. No, there is no difference, Nishant. It's customary. I'll show you. See. Once we are done with these parliamentary topics, we'll then pick up your parliamentary versus presidential form of government. एक बार ये पूरी चीज़ें हो जाए, फिर हम उसको अच्छे से समझ पाएंगे कि भाई करना क्या है और क्या नहीं करना है. ठीक है? Clear on this? Understood? Okay? Good. Thank you, Basim. I hope you guys are understanding how structured polity is. I hope you guys are understanding कि इतने डेप्थ के ऊपर हमें नहीं जाना है. When you see the previous year questions, you see इसके ऊपर ministries में कुछ नहीं आएगा, right? एंड बसीमा ये एक्चुअली कम कंटेंट नहीं है, ये उतना है जो हम सीधा कट कॉपी पेस्ट करके मेंस में लिख सकते हैं. मेंस में यही आएगा, हमको यही लिखना है और हमको अपनी ज़िंदगी में मेंस क्लियर करना है. हमें प्री क्लियर करना है, हमें मेंस क्लियर करना है. बाकी ज़िंदगी में जो चल रहा है चलने दो, कोई लेना देना.